Okay, it's a little after 1:30, so we'll call the Board of Commissioners public hearing to order, July 29th, 2026 at 1:30 p.m. This is on file number 439-25-00005-LRP. And the purpose of this continued public hearing is to consider a Planning Commission recommendation of a proposed minor comprehensive plan and zoning map amendment for a statewide Planning Goal 11 exception to allow connection to a future Rogue Valley Sewer Services sewer line and add 14 parcels consisting of 19 tax lots to Area of Special Concern ASC 2003-1 Goal 11 exception areas on a total of 797.55 acres zoned woodland resource, exclusive farm use, rural residential 5 and rural residential 2.5. The parcels are located off Wards Creek, Sardine Creek Road, Highway 99, and North River Road, Gold Hill, Del Rio Vineyards LLC, Wallace Family Trust, and Lynn M. Steele and Donna Cristela Williams are the applicants. This is file number 439, again, -25-005-LRP. With us today, with our planning staff, is Ted Zook, Director of Development Services, Kristen Mays, Planning Manager, and Don Cox, Planner 3, and our legal staff, Pete Philbrick, Deputy County Counsel. And at this time, request the admonishments and the rules of the public hearing from County Counsel.
Thank you, Mr. Chair. Here are the rules for this continued public hearing. Board of Commissioners is obligated to follow its comprehensive plan, its land development ordinance, and state statutes when it continues legislative changes to its land development ordinance. Therefore, please remember to direct your testimony and evidence toward the legislative criteria set forth in the published notice for the hearing today. We are making a recording of the hearing. In the event of an appeal, it may be necessary to transcribe it. Therefore, when you testify, please begin by identifying yourself so that anybody reading a transcript of the record will know who's talking. We will first hear from staff, then we'll hear from those who wish to testify about the proposed minor comprehensive plan and zoning map amendment. Once everyone has had an opportunity to speak, the public hearing and the record will be closed unless there is a request for continuance. However, if there is no continuance, then the commissioners will proceed to deliberate toward a final decision. Finally, this is an opportunity for the commissioners to announce whether they have any ex parte contacts. If ex parte contacts have occurred, please discuss the nature and content of the ex parte contact or contacts so that the parties are aware of the substance of the communication when the hearing is open today and have an opportunity to rebut any evidence obtained in ex parte contact. Also, this is an opportunity for the commissioners to announce whether they have any actual or potential conflicts of interest with respect to the matter today or the applicant. If so, the commissioners can discuss the nature of that actual or potential conflict and how they wish to proceed. Are there any ex parte contacts or conflicts of interest to report?
I have none.
I don't have any since last hearing.
And I have none.
Rules for the conduct of public hearings are as follows. Only the chair or a member of the Board of County Commissioners may question a speaker. There will be no interruption of a speaker from the audience and no debates on the floor. Applause is not permitted. A speaker may criticize a proposal of the board or an agency of the county, but a speaker shall not argue with another speaker directly. A speaker may present an opposite view, but not in personal terms. A person wishing to speak shall raise his or her hand and be recognized by the chair conducting the hearing. After being recognized, the speaker shall state his or her name or address before proceeding with his or her statement. And the chair may limit the duration of any presentation to the time necessary to cover factual information. Repetition shall be avoided. Thank you, Mr. Chair.
Thank you. And at this time, then, we will request the planning staff report.
Good afternoon, Commissioners. I'm Don Cox, Planner 3, 10 South Oakdale, Medford 97501. The application before you is a request for an amendment to the Jackson County Comprehensive Plan by taking an exception to statewide Planning Goal 11 for a total of 14 parcels containing a total of 797.55 acres. Additional information submitted by the agent on June 29th, 2026 includes that parcel N is being removed from the proposal. Parcel N contains 392.66 acres, bringing the total proposed acreage down to 404.89. Additional information submitted by the agent on July 28th, 2026 includes an interpretation of Goal 11 reasons, exceptions, and LUBA case law, but does not include the substantial findings that support no practicable alternative to existing and approved DEQ septic systems. Staff has evaluated the new information against the applicable criteria and has found that the OAR criteria has still not been met. Here's a list of the applicable Goal 11 criteria. For this case, the OARs shown in red have not been met for all parcels. Bear with me, the next few paragraphs have a lot of technical data from the OARs. OAR 660-011-0060 sub 9 states no practicable alternative to a sewer system, which means a determination by the Department of Environmental Quality, DEQ, or the Oregon Health Division, or significant findings that an existing public health hazard cannot be adequately abated by the repair or maintenance of existing sewer systems or on-site systems, or by the installation of new on-site systems. However, the evidence submitted must be more than abstract and speculative to illustrate an imminent and significant public health hazard. The agent's supplemental findings do not adequately address why existing septic systems and DEQ septic approvals cannot accommodate all of the existing and proposed uses on the subject parcels. The agent's supplemental findings on page 49 of the BOC record state many of the septic systems and leach fields at the site are operating in a relatively effective manner. However, it is also probable that many of the septic systems and leach fields are not thoroughly treating wastewater. The report refers to septic discharge of wastewater, which may or may not impact the Rogue River and salmon as an endangered species. The county relies on DEQ as the experts to determine if a septic system will have any environmental impact on water quality. Environmental impacts related to Endangered Species Act are not a listed standard or criterion for Goal 11 exception. Therefore, staff has not addressed ESA implications. Not all uses have been described to provide an explanation of why the proposed uses cannot reasonably be accommodated without the provision of the proposed public facility. Vacant residential is not an adequate use description to connect to sewer, as all uses must be listed and justified. The proposed uses must be compatible with other adjacent uses or designed to reduce adverse impacts. Without all listed existing and proposed uses, all of the parcel's compatibility with other adjacent uses cannot be determined. The Planning Commission recommended a partial approval, sites shown in blue on this map, and a partial denial. Those sites are shown in red at the hearing on April 9th, 2026. Based only on the use table included on page 34 of the PC record that did not include septic approvals, authorizations, or denials, which are necessary findings for a Goal 11 exception. This map indicates parcels with DEQ septic feasibility in light green and parcels in dark green that have installed septic systems. The tax lots shown in yellow have no DEQ septic information. Parcel L, shown in red, has a DEQ septic site evaluation denial. Therefore, based on OAR criteria, this is the only parcel that is eligible for approval of a Goal 11 exception. As noted in this map, 5 parcels have existing septic systems and 6 parcels have DEQ septic approval, and therefore wouldn't qualify for a Goal 11 exception. The board may move forward with other options. However, based on the findings from staff, and approval of parcel L is recommended today. Are there any questions of staff?
I have a question.
Yes.
So, Don, what did the 20-day continuance, did it do for what you have?
It allowed staff to read through the supplemental findings that were given before the hearing, right before the hearing, and then we got additional findings yesterday, supplemental findings.
And you've reviewed those?
Yes, I have.
So it's staff's opinion that these exceptions, Goal 11 reasons exceptions, the agricultural land and the leach field that would detrimentally affect this agricultural property, and the potential for water quality impacts doesn't in any way qualify that for an exception.
So are you talking about the ESA argument, or are you talking about, I need more information from you, please.
Well, basically, the argument is that there's a septic system, and the leach field has to be into the existing agricultural property. It's going to damage and again, limit the use of that agricultural property, which of course is something that goals and priorities suggest that we want to preserve the agricultural land as much as we can. That particular argument, is that not what you would consider a reasonable exception for a Goal 11 exception decision in this case?
So parcel M is the winery and wine production, and that's one of the ones that we didn't get additional information aside from the hydrogeologist's report. I'm actually more concerned about the rural residential properties below.
Okay.
Concerned how?
Concerned that we don't have enough information to determine whether or not we can get a Goal 11 exception for those based on uses, and determine whether those uses are compatible with the surrounding uses. That's part of it, is we had to do the analysis of, will the proposed uses be compatible with the surrounding uses?
If I may interject, I think it might be prudent to hear from the applicant, Mr. O'Connor. He has a different argument, and it is a reasons argument on a different administrative rule. I think if we look at face value of the administrative rule, what we have here, it clearly says you need to have a reason why you can't have a septic, and you can have a septic. Some of them even actually have septics. Mr. O'Connor's argument, and I don't want to be giving his argument for him because it's his, but just for context, his argument is the reasons exception supplants the first two parts of the OAR. When we look at something for a septic system, we're looking at DEQ, and DEQ says, can you have one or can you not? I believe Mr. Connor's argument is he has a reasons exception that goes beyond that.
Yeah.
Our read from what we're getting from DLCD is that number 9 section, I can read the whole section if you want, but it's basically would be something for you to determine as a board.
Okay.
But I guess I'm getting way ahead of myself, and maybe Mr. O'Connor can do it a little more eloquently than I did.
I'm sure he can. No slight to you, Ted. All right. And no more questions?
Not right now.
Okay.
Maybe hold questions for later.
Yeah. All right. Then we will open the public hearing, and we'll start with the applicant. So Dan?
Good afternoon. I'm used to saying good morning to you, but good afternoon. My name is Dan O'Connor. For this Goal 11 exception application, I am representing Del Rio Vineyards. Lynn Steele, a neighbor, and then the Wallace Family Trust is also included in the application. Just a quick point of clarification on we removed what was parcel N. I think we have a difference of acreage calculations. Parcel N include tax lot 100 was 387 acres, tax lot 200 is 81.93 acres, and tax lot 400 is 5.12 acres, and tax lot 800 is 79.98 acres. So with the removal of that, our numbers are that the total area is 238.46 acres. Had discussions with DLCD about reducing it further. But the issue is that parcel M, that's the large parcel, it's 213 acres, is one legal parcel that contains the main production facilities. And so there was a discussion with DLCD, had a discussion with the county. The county's position is, as I understand it, is that if it's a legal parcel, the entire legal parcel needs to be included in the exception area. You cannot say a portion of that would be. My position is I agree with the county's position on that. DLCD was going to look for some authority, but has not provided any authority concerning that issue. And so as of now, the total area is 213 acres. Without parcel M, that's the big legal parcel with the production facility, the total exception area is 25.06 acres. And so, as was said, this is a reasons-based exception. And I wish this could be a quick presentation, but I think it'll be informative because this Goal 11 stuff is confusing, clearly, not just with Jackson County, but with other counties around the area. So the submittal yesterday was not supplemental findings. I've been working with Kevin Young, Jocelyn Bombard, and their Goal 11 expert, John Jennings, with DLCD. And what that memorandum was the state rules framework of how Goal 11 exceptions work. And so I noticed that the criteria had changed, which I appreciate. I still think it's incorrect on the applicable standards and criteria, but before it was relating to a provision, and the confusion was caused inadvertently by Kevin Young at DLCD, who sent an email in, cited a specific section, but that section was a definition. It was not standards and criteria. And that's what initiated the discussion with DLCD, because I did a deep dive into this. There was errors on our part initially on our submittal, but I think since the Planning Commission hearing, we've been communicating with the county, done the research, and have a strong handle on the applicable standards and criteria. This may be a little much, but I'm going to hand you each, if I may, a copy of the goal. It's the OAR, and I can walk you through it. Is that okay?
Thank you.
Our position is that the controlling criteria, and really the only criteria under the OAR, is OAR 660-011-0060, subsection 9. And just another, and this was kind of back and forth, sorry for the late notice, but it was like I was pinging DLCD on that, but they did respond, and DLCD agrees. with me, that's the criteria. That's from John Jennings at DLCD. May I step forward? I can just read this to you, or I can give you a copy. I've got extra copies. Your preference, up to you.
Yeah, I'd like to take a look at it.
Okay.
That's our second, okay.
Got plenty of it.
In this is a correspondence chain back and forth with, I had a conference, a Zoom call with the DLCD team based on my supplemental findings that were submitted June 28th. And so what it was I set forth a position in the supplemental findings. I wanted to make sure that I wasn't off track, and that's why I was working with DLCD to get the appropriate standards and criteria. And you'll notice in that chain that from Jocelyn Bombard that I'm looking here for it. Oh man, you know what? I didn't double-side the copy. I did forward the email to Dawn this morning, because I just got it this morning, and DLCD had, in their position was they had no concerns with the proposed Goal 11 exception. And so to really figure out how this is working is, my position has been all along, since I've gotten involved, there are different types of Goal 11 exceptions that you can take. There's a public hazard, that's the imminent, no practicable alternative. There's what I call a section in in the OAR provisions that I just gave you. I'm getting my notes. Is okay on the public health hazard exception route. That is subsection of the text I gave you, 4, 5, and I did I highlighted in yellow just so you can see the numbers. It's subsections 4, 5, 6, and 7. So there's 3 primary paths for a goal exception. Well, let me rephrase that. There's 3 primary paths where a local government can allow an extension connection outside of an urban containment boundary or an urban growth boundary. And so that's the 3 paths I'm gonna talk about. The first one, like I said, is the public health hazard. No practical alternative. In the other one which is very important in Jackson County, because I'm not sure this has been the practice, is if you're located within 300 feet of an existing sewer line and it's a sewer district that serves it, and you've had a residential use that was established in 2005, you don't need a goal exception. You just need, all the county needs to do is you need to meet these certain standards. And I'll tell you, just so you know, you can connect to sewer without any sort of comprehensive plan amendment if the following standards are met. Lawfully created parcel within a sewer district service boundary. The lot or parcel is zoned rural residential. The residential use must have existed on July 1st, 2005. The existing sewer line is within 300 feet of a lot or parcel, and the local government determines that it is practical to connect to the sewer line based upon geographic features or man-made constraints. That's the one avenue. The other one is the public hazard, no practical alternative, and that's where DEQ has determined that there's an existing public health hazard. And I'm not asking you to read through these provisions, but when you look at those sections 4, 5, 6, and 7, it's pretty clear, you know, that's one path. In 2005, LCDC adopted OARs, I'm not going to call it legislation, you know, it has effective statute, for a reasons-based exception. And that's to allow local governments flexibility in, you know, granting certain exceptions based on appropriate reasons. Whether or not a septic system is on the property, whether or not it is functioning, whether or not one was denied or not denied, is completely irrelevant. As it's just, it needs to meet the reasons-based exceptions. So, and that is OAR 660-1100-609, just like in the DLCD correspondence. In that one, I'm gonna read it. I'll paraphrase as much as I can, it's not that long. A local government may allow the establishment of a new sewer systems or the extension of sewer lines not otherwise provided for in Section 4 of this rule. Section 4 is the public health hazard, no practical alternative. That's when the septic system comes in. So that is not relevant here. Or allow a use to connect to an existing sewer line not otherwise provided for in Section 8. Section 8 is the one where you're within 300 feet of an existing sewer line in your zone residential, provided the standards for an exception to Goal 11 have been met. That is 660-04 in statewide planning Goal 2, Part 2, which is the exception process. There's 4 kind of main kind of criteria on that one. And provided that local government adopts land use regulations that prohibit the sewer system from serving any uses or areas other than those justified in the exception. In that last language I read, the county, they have done a good job on the mapping and, you know, identifying specifically the property. After the Planning Commission, whatever they asked for, we provided. We provided the septic, you know, analysis. We provided the uses. They initially had provided that you needed a Goal 14 exception to, I think, develop under a parcel under 2 acres, which is not the rule. And I think that's been backed off on. So back to this OAR provision, appropriate reasons and facts for an exception to Goal 11 include, but are not limited to, A, the new system or extension of existing system is necessary to avoid an imminent and significant public health hazard that would otherwise result if the sewer service is not provided, and there is no practical alternative to sewer system in order to avoid the imminent public health hazard. So you notice the difference there. It's an imminent versus existing. Or B, the extension of an existing sewer system will serve land by operation of federal law, is not subject to a state planning Goal 11, and if necessary, Goal 14. So at first blush, you're thinking, well, Dan, you just said I didn't need to worry about imminent public health hazard. And so the controlling case on this is Land Watch versus Deschutes County, where LUBA specifically interpreted this section, subsection 9. I'll call it 60 subsection 9. In that case, the LUBA says, and DLCD agrees, it is important to note that subsections A and B are simply examples of appropriate reasons to allow a Goal 11 exception. But as the text of 60 subsection 9 makes clear, this is not an exclusive list of appropriate reasons. This interpretation was specifically adopted by LUBA and Central Oregon Land Watch versus Deschutes County, which is the controlling case law on reason based exception. In fact, LUBA substantially broadened the scope of available reasons that can be used to justify a Goal 11 exception to extend sewer lines for the benefit of specific parcels. Where that language where they talk about, a imminent public hazard, or that they say it could be inevitable public health issue. It was never the intent of those examples to pigeonhole a local government into, you have to comply with those two examples. For example, in the Deschutes County case, Deschutes, DLCD, and DEQ proposed to bring in, get a goal exception, a Goal 11 exception for 14,000 lots covering an area of 180 square miles. And so in LUBA's analysis, what killed that case for that application was there was only like 3,530 of the lots had a high water table, which would be, subject to nitrates and the phosphorus and that sort of contamination. In its dicta in the case, LUBA said if the county, Deschutes County, unlike Jackson County, failed to provide the specific property information and the mapping, but they had done enough to determine that these 3,000 plus lots had high water tables. The strong dicta in that case says if the county had complied with those provisions that Jackson County has, that was an approvable Goal 11 exception for over, it's like 3,500 lots. And so in this case, and if you go in, I believe it's 660.04.20, well, they give, because you got to remember, goal exceptions can happen on any goal, typically. And they give examples of different, like for certain types of uses, these are allowable reasons. Our position is preservation of ag land on parcel M, preservation of its Goal 3, the exception is totally justified for that, because if we had to do a new system on there, it's just going to eat vineyard. And then our other one is that my environmental consultants, to be very specific, that because there are threatened the threatened Southern Oregon, Northern California coast coho salmon, is to protect it from nitrogen and phosphorus is a legitimate reason for a Goal 11 exception. Septic systems don't treat phosphorus. RVSS treats for phosphorus. And so our position is this is a very reasonable, simple, relatively simple goal exception. All we're proposing to do is extend the sewer line from the Sardine Creek facility. Once RVSS completes that work, and I checked in with RVS, that work is going to start in the spring. We're just going to extend it down to serve these properties. And based on the environmental report, the environmentalist is also a geologist, that this is a benched, I think it was basalt bench. And so you have a shallow water table. I think it was 78 to 138 feet, something like that. And so it's directly discharging into the Rogue River. And then also one other just side note is on the Goal 14 exception stuff, we did a zone change, I think it was 2012, somewhere in there, where because a lot of this land was zone EFU on the riverside of the railroad tracks, and actually Rogue Advocates, Jimmy McLeod, was supportive of that, and so we did get Goal 14 because that's when we zoned it to RR2.5. But the reason for that was that the conditions on this alluvial, whatever, this shallow alluvial thing, is it's not good for farming. And it's also, it doesn't perk deep on septic systems. And these are completely valid reasons under the OARs, under the statute, ORS 197-732. The one thing is there's the 4 standard, call it exception criteria, that's based in statewide planning goal 2 and is set forth in OAR 66004-20. In Luba discussed those. A sewer line is not a use, it's a utility. It's so the ESEE analysis, even though we did it, we addressed those standards and criteria. Is it the ESEE analysis? Is it compatible with other uses? Those type of things. Even the dicta in the land watch case is like, well, this is a little bit of a different animal because it's a utility. I have power that comes to my house. My use isn't a power. I'm not a power use. And so those, even though we addressed them in the application findings, even Luba says on the goal 11, it's really not really applicable because it's a utility use. It's not where you'll see these goal exceptions for solar facilities and that sort of thing. It's just different than that because it's just simply in a utility extension. And so our position is, this is nothing extravagant about this application. It's limited in size to address the issue, and that's basically it. There's no reason not to approve the goal 11 exception for these parcels. And I'm available for any questions.
Any questions?
Yep, I do.
Okay.
A couple. Why, so you've excluded section N, is that correct?
The parcel N,
Parcel
it was,
N.
and I'm not exactly sure why that was included in the first place. That was, that was the vineyard section that is up the hill from the main facilities and that. And so there was no, DLCD asked if we could shrink it, we did, and so that's, the big parcel was removed from it.
Okay, I was wondering why that was
Yeah.
selected, but that's the only parcel you're removing.
Right.
And it's down to what is the value of having the acreage down to 213 acres versus 250 or 400 or? What is that pertaining to?
It was just messaging from DLCD about, trying to limit the size of what the exception area. Okay. And then upon further analysis on our part, it really wasn't necessary to have it for that piece.
Because a section N is so small and compared to the whole project, it surprises me it takes half of it out.
Well, it's parcel N, and it's like, I don't have the.
Well, just almost I don't know how accurate.
Can we get the map up?
Accurate this is, yeah, that'd be good. Because N is three sections on this, but it's very minute.
It's Commissioner Roberts, it's the big one, up the hill.
That's
It's
M.
that's M.
And
See,
then right next to
you're
it,
just
left.
showing a little portion of N.
Oh,
Yeah, N goes way to the north. It goes up the valley at Del Rio.
okay.
Yeah.
It does not show that.
Yeah.
Thank you.
Uh-huh.
I don't think it would hurt to have it up there. It's kind of
Nope.
important to refer to when necessary. So no other questions? All right. Thank
Just
you.
like the right reserve rebuttal, please.
Absolutely.
Thank you.
All right. We now have Steve Rouse.
Good morning, Commissioners. My name is Steve Rouse. I'm the President of the Board of Directors of Rogue Advocates, and we're here to provide testimony in support of the Planning Commission and the staff's denial of this application. I do have written comments, and I'm basically going to go along the same lines that Dan did. I didn't hear anything today that sways my opinion that this application should be not denied, but if you want to follow along, I'm happy to hand out the, okay.
All this stuff straight here. Thank you.
So our testimony today will focus on Mr. O'Connor, the applicant's supplemental findings that are dated June 28th, 26. I have not seen what was submitted yesterday, but like I said, what I saw Dan present, I don't think it's changing any of the facts that we're going to refer to. And we're going to focus on the same statute that Mr. O'Connor focused on, which is the 00609. The applicant is seeking a reasons-based Goal 11 exception for the proposed sewer line extension connection. That application, as presented, is flawed by failing to satisfy the criteria of appropriate reasons and facts for Goal 11 found in the OIR I cited, the number 9. The OAR reads, appropriate reasons and facts for an exception to Goal 11 include, but are not limited to, A, the new system or extension of an existing system if it is necessary to avoid an imminent and significant public health hazard, and that would otherwise result if the sewer service is not provided, and there is no alternative available. And B is also in there, but it doesn't apply. The extension of an existing sewer system will serve land that is under operation by federal law and is not subject to Goal 11. So Goal A is the criteria that this application turns on. And the key language there's two key words. The appropriate reasons and facts include but are not limited. Now, Dan went into the fact you can have a lot of reasons, and you can have multiple reasons, but they must include A and B when applicable. And the problem therein is that there's no evidence to support that an imminent and significant public health hazard exists either on any of these parcels. That's the problem. In A, the applicant goes on to present in the supplemental findings. Let me make sure I'm on the right page here. I think I am. Okay. The applicant's supplemental findings in Section 4 state it is important to note that these subsections are simply examples of appropriate reasons to allow a Goal 11 exception. But the text of that OAR makes clear that this is not an exclusive list of reasons. That's true. It's not an exclusive list, but it must be included. We disagree with the interpretation as presented by the applicant, that these are simply examples. The text clearly states that the reasons include sections A and B. The applicant has attempted to present evidence that the sewer line is necessary to avoid an imminent and significant public health hazard. Does that evidence exist in the record? The applicant continues in his supplemental findings, citing two examples. One, the protection of agricultural lands, the failure to allow the main facilities parcel, which is parcel M, to connect to the RVSS facility will inevitably result in the irreplaceable loss of productive agricultural land. Productive agricultural land is protected under Goal 3. It is not relevant to Goal 11. B, the threatened species protection. The failure to allow the proposed Goal 11 parcels to connect the RVS facility will inevitably exacerbate an existing water quality hazard, which is a health threat to both humans and fish alike. That's a quote from his application. These reasons and the supporting statements fail to demonstrate an imminent and significant public hazard as required in the criteria of 9. The applicant contends the failure to connect the sewer line will inevitably create these issues, but they do not demonstrate that they are imminent. In reason A, the applicant provides no evidence that the existing sewer system is failing or can't be repaired. As a matter of fact, on parcel M, that DEQ says that septic system is working fine. That's the large parcel where the production facility is. In reason B, the applicant provides no evidence that the parcels are directly contributing to an imminent, significant public health hazard. In fact, these parcels do not have an existing septic system, so they cannot possibly contribute to an imminent issue. If there was an existing water quality hazard caused by properties with sewers along the Rogue River, then this Goal 11 exception may apply to all properties along the Rogue River from Rogue River to Shady Cove.
I'm going to have you pause for a second. Testimony from the public, are we limited to 5 minutes there? Is that our, because I want to make sure.
Generally, we are. It's up to the chair's discretion to extend that if you
I'll just ask you to wrap up real quickly here, because generally we limit the public testimony to 5 minutes, and we need to be consistent, so.
I am the only public here, though, so.
That's true, but we need to be consistent throughout our hearing, so I'm going to ask you to wrap up quickly.
Okay. So I'm going to discuss the Luba case that Mr. O'Connor cited, which is Central Oregon Land Watch versus Deschutes County, because we disagree with his conclusions and interpretation of that. The applicant includes a lengthy quote from the Luba Oregon Land Watch decision, it involved, again, extending sewer service to rural areas. However, the immediate paragraph following the applicant's citation sheds light on the Luba decision in that case. And Luba states, following what Dan quoted in his supplemental findings, Luba states, the problem is not that those are the facts that the county found. The county has not found that it is necessary to extend sewers. And so before you, the question is it necessary to, has the applicant demonstrated that it's necessary to extend the sewers? I can stop there.
Okay, thank you.
All right.
Yeah. All right, rebuttal from the applicant?
Dan O'Connor. Yeah, as to the interpretation of the case, I'll read you the direct language from the case and you can decide. This is talking about the two examples. Luba says, we first examined the text and context of the rule, determined the intent of LCDC in adopting the rule. The text of the rule includes the phrase, include but are not limited to, in describing examples of appropriate reasons and facts that could justify a reasons exception to Goal 11. When they precede a list of examples, statutory terms such as includes and including but not limited to typically convey an intent that the accompanying examples be read in a non-exclusive sense. That is exactly the opposite of what Rogue Advocates was arguing. Our interpretation of the general term appropriate reasons and facts includes consideration of the specific examples listed. According to listed examples are two examples of appropriate reasons and facts that could justify a reasons exceptions as examples of appropriate reasons and facts for an exception to Goal 11. OAR 6 subsection 9A and B also provide context for determining the scope of the general term appropriate and reasons of facts, but they do not state the only acceptable reasons and facts for an exception to Goal 11 to extend sewer systems into rural area to resolve health problems, public health problems. So there's flexibility, and then I find it interesting that an environmental group would challenge an RVS sewer line extension, because even in discussions with National Marine Fisheries Service, I mean, their position is that Goal 11 violates the Endangered Species Act. So a little confused why Rogue Advocates would be opposed to putting more properties on an RVSS line. That's all I have. Thank you.
Okay. Boy, now I'm going to have a hard time finding my...
You're looking for your checklist.
Yeah, I've got dozens of papers I've been shuffling around. You have your original one? Thank you. Okay. If there's no one else to speak, nobody online?
Mr. Chair, there's no one with their hand raised online.
Okay, thank you.
A question, I don't know if I need to wait it for deliberation, but I just want to clarify the recommendation before us. It was presented as if it was a denial by staff and the planning commission, but isn't staff's recommendation to approve the tasting room? And wasn't the planning commission to approve like C, E, G, L, M, and N? Okay, I just wanted to confirm that. Thank you.
All right, we will then close the public hearing. And how many exhibits do we have to enter?
The 29?
With the 3 documents provided today, I have 19.
Oh, 19.
Okay,
All right.
so I'll take-
I will move to admit exhibits 1 through 19 into the Board of Commissioners record for file number 439-25-00005-LRP and to close the record.
I'll second.
All right, then we will deliberate on this. Does anybody want to start off with their assessment of this?
Do we have to vote on my motion?
Oh, I'm sorry, yes, we do. Well, let's do that.
Commissioner Sparacino?
Yes.
Commissioner Roberts?
Yes.
Commissioner Dyer?
Yes. Okay, now we can move on to deliberations. So I guess the way I look at this is there are exceptions. There is flexibility. There's discretion given beyond, just the basic rule, the no practicable alternative, and one of those and the reasons exception do exist. And I believe it's impossible, I think, there was evidence that was given that indicated that, yes, this is going to could irreversibly damage agricultural land. I think a leach field in a vineyard can certainly be reasonably assumed that may damage that land. And as far as leaching into the river and creating a public health hazard, again, I don't think that's a stretch to think that that's a possibility, and some of the evidence suggests the threat to salmon and other wildlife. I don't think that we're making a huge stretch to accept that premise that there would potentially be public health hazards and other impacts from a septic system. We have a sewer system that's being extended very close to the property. The proximity seems to be a reasonable fact to consider, and whether a hookup here is, again, a reasonable request or application to approve. So that's why I'm looking at this. Like I say, these exceptions exist for a reason. They do give us latitude. They do give us discretion. They do give us the ability to look at this and say, is this something we can reasonably say qualifies under these exceptions, these rules exceptions? And my opinion is they can.
And I agree. I look at the reasonableness of the request, and if the line goes to support the tasting room, it's almost within those 300 feet, acceptable distances from the other parcels. I appreciate the Planning Commission's recommendation that was more selective, but left out a few. In my opinion, I just think the applicant's taken out N, and I would support all the other parcels for approval. But do you want me to make that motion?
If you'd like to.
It's not one of our selections, but I would, based on the evidence and testimony, I move to approve the application, less parcel N, for a minor comprehensive plan and zoning map amendment for statewide planning goal 11 exception to allow connection to a future Rogue Valley sewer services sewer line and add the 13 parcels to an area of special concern 2003-1 goal 11 exception areas. I hate to quote the acreage, it's 213 acres, but the applicant said that's what it was. Zoned woodland resource, exclusive farm use, rural residential 5, rural residential 2.5, and the parcels are located off Woods Creek Road, Sardine Creek Road, Highway 99, and North River Road, Gold Hill, Del Rio Vineyard LLC. Applicants, file number 439-25-00005-LRP.
Second.
Okay, any additional discussion?
Commissioner Sparacino didn't get to weigh in before I moved, so.
The point that Commissioner Roberts made with regard of bringing the line all the way to L, you're already almost covering the entire project, so I see a reasonableness standard there. So I can concur with that.
All right, we'll take a vote.
Commissioner Roberts?
Yes.
Commissioner Sparacino?
Yes.
Commissioner Dyer?
Yes. Okay, then we will ask staff to prepare an ordinance of approval, and we'll set the dates for first and second reading and public hearing of the ordinance. First reading, August 19th, 2026, here at 9:30 a.m., and the second reading of September 2nd, 2026, at 1:30 p.m. here in the courthouse auditorium. And with that, we'll adjourn the meeting.
Best way to spend my birthday.